All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV130757, Smith versus Alameda Land and Cattle Company. Counsel, we are recording today's proceedings, so when you step to the podium, if you would please identify yourself and your client. Each side will have 20 minutes for argument, and appellant's counsel is responsible for watching the clock and reserving any time for rebuttal that you might desire. We have read the briefs. We have conferenced the case prior to argument. We believe we understand the issues. With those preliminaries out of the way, Mr. Winger, you may proceed.
Thank you. May it please the court. Chad Winger on behalf of the plaintiffs in this case, Craig and Marcia Smith. We're here today. The issue before the court is whether or not the trial court's grant of summary judgment in this case was error. And the grant of summary judgment in this case rests and relies on the proposition that grazing permit holders owe no duties to users of U.S. Forest Service land because they have no ownership or possessory interest in the property. The trial court's decision is erroneous because the defendant in this case installed, maintained, and used the electric fence that caused the accident that gives rise to the damages for Mr. Smith. Now, I think the issue is fairly simple in this case. However, I believe that the record is somewhat convoluted and a little bit confusing. I want to start with the issue of the fence. I think it's uncontested that the electric fence in this issue was installed and that Alameda had the duty at the time of the accident to both had the duty to maintain that fence.
Well, let's talk about that just for a second to make sure I understand the record. I think there's no dispute that Alameda constructed the fence, and it also appears in the allotment management plan that they were required to construct an electrical fence along a certain portion that uncovered the place where Mr. Smith had his accident, correct?
That's correct. That's correct, Judge Downey.
And as soon as it was built by law under the CFR's title to the improvement vested in the United States.
Judge, we would not concede that point. In fact, our contention throughout this is that the installation, maintenance, and use of this fence it gives rise to Alameda's duty. Now, the appellee...
I thought the CFR was pretty clear.
I don't think the CFR...
When the improvement is built,
well,
ownership goes to the federal government.
Well, Judge Norris, I think it depends on what type of structural improvement we're talking about. Is it a permanent structural improvement?
Well, permanent structural improvement is defined by the CFRs as including fences. I mean, this is an important point, and so you're not conceding that under the CFRs the United States was the owner on the date of your client's accident? We're
not conceding that point, and in fact, I think this was the main point I wanted to bring to the court's attention here today, is that under the CFRs, the definitions in 36 CFR 222.1, subsection 21, 2A and B, there are definitions for structural improvements. The subsection A, or the subparagraph A being permanent structural improvements, the subparagraph B being temporary structural improvements. Now, fences are listed as permanent structural improvements in subparagraph A. However, in subparagraph B, electric fences are considered temporary improvements, and that is the type of fence that is at issue here in this case.
Although it wasn't electrified at the time. It was just a fence at the time.
It was an electric fence, and it was not, the record does demonstrate that it was not electric at the time. However, the question is, where did ownership vest at the time that the construction was completed? Now, there's nothing in the record about whether it was electrified. However, it is an electric fence. It is able to be electrified.
Had it ever been electrified?
I believe that it had, and I believe that that's in the record, that it was used as an electric fence at some point in the past. For what purpose would the ranchers build an electric fence yet never electrify the fence?
No, it had been used for the purpose. It wasn't its intended purpose. It just wasn't electrified at the time of the accident.
That's correct. Otherwise, Mr. Smith would have had much more serious injuries.
So then the issue as to whether it's a permanent or a temporary improvement, I guess what you're saying is turns on what?
I think it turns on the nature of the fence. The fences in the permit, there is a requirement that Alameda maintain the fences in the permit.
Right.
Now, the general term fences are used there, but the fences that are described in the permit are 4-wire fences. These are barbed wire fences. So in the permit, when the term fence is used, and I believe in the CFRs, when the term fence is used, we're talking about 4-wire barbed wire fences. The fence in this case was a 2-wire electric fence. And so I believe that it falls clearly under the definition of a temporary structural improvement. And in the CFRs, under 222.9, 36 CFR 222.9, I believe ownership of structural improvements are categorized. So there are categories of structural improvements, and then the CFRs explain which categories are owned by whom. Permanent structural improvements, as was cited in Appellee's brief, clearly are included as permanent structural improvements that where ownership vests in the United States. However, if you go to the next paragraph down in 36 CFR 222.9, what you find is that temporary structural improvements may continue to be owned by the cooperator, and the cooperator in this case would be Alameda, the person under the cooperative agreement who was authorized to build the fence, that ownership may be retained if they if the U.S. didn't fund the construction.
And is this an argument you made in opposing summary judgment in the trial court?
Well, I believe it's implied in our briefs that our contention has always been that Alameda is responsible for this fence, and that Alameda owns this fence.
Is there
But
anything?
that's not the precise question, though.
Yeah, I mean, I've got your response to the motion for summary judgment, and I'm trying to find where you preserved this argument, because as I recall the briefing, Alameda always took the position that the United States owned this fence, and so I'm looking for where you raised the argument you're raising here, because as you know, we don't address new arguments on appeal.
I don't think it was explicitly briefed in the response for motion for summary judgment.
Then have you waived it, then?
I don't believe that we've waived it. Moreover, I was going to get to the point that I don't know that it necessarily matters for the analysis before the court. Because
Before we get there, you mentioned that some temporary improvements can be owned by the cooperator if the government did not pay for them. Is there anything in this record about who paid for the fence?
I'm not sure. I'm not positive, but I do believe that it is in the record that it's clearly and unquestionably was Alameda's fence and that they built it. And I believe the permit actually outlines the cost that would be spent on the fence.
So assuming, we'll look at the record and we'll, whether waived or not, you're about ready to launch into a different point.
Well, the point is that I think our primary contention is that under the Clark case, ownership of property, possessory interest, property interest is not necessarily what is required for a duty to be found. We believe that Alameda had the right under the permit and was granted the right by the U.S. government to use the U.S. government's land, and that in that use they had to be responsible in their use of the land.
Let's backtrack just so I understand your exact argument on premises liability. We all agree that Alameda didn't own the property, so it's not a property owner. And so it seems to me you have to be relying on the alternative basis for imposing premises liability, which is it's either a person who is owns the land or a person who is in occupation of the land with intent to control it. So is that the basis upon which you claim Alameda has premises liability?
That they, in a way, controlled the land through the fence, that they constructed the fence, that they maintained the fence, that they use the fence to control their cattle, and so therefore they have a duty to other users of the land and a special relationship with other users of the land to be responsible in the manner in which they use and to the degree in which they control the land.
Did you find any case, because honestly, with grazing being so common in the western United States, you would think some court had addressed this issue of premises liability by permittees of grazing land, and I couldn't find any, but the Clark case to me, I agree you don't have to have a possessory interest per se, but you've got to have occupation of land with intent to control it. And the case law in other contexts on grazing permits suggests that these are not whimsical, that's way too broad a characterization, but they are not secure enough interests in land to carry with that interest certain other obligations. Did you find any case anywhere that said permittees of grazing land owe premises liability duties?
Your Honor, had I found such a case, I would have certainly cited it in my brief. And while I was not able to read every case in the common law, I did not find any case specifically on point. I think Clark is the most analogous case to this situation.
But Clark's distinguishable for a major reason. An easement is a servitude, and a servitude gives rise to premises liability duty. No way is a grazing permit a servitude because it cannot be, it doesn't run with the land. And so Clark, I understand why you talk about it because it's one of the few arguably analogous situations in Arizona case law, but it just seems wildly distinguishable because the easement owner also can exclude others from using the property that interferes with its easement. It's not subject to the control of the landowner in the use of its easement. An easement just seems very different from a grazing permit, which it's not revocable at will, but in some ways it's pretty close, and it can be revoked if the cattle are overgrazing in certain parts. It's just a very different animal, so to speak.
Well, in answer to your question, I don't believe that Clark is directly on point. I believe it's the most analogous case, as I stated previously. But I think the way I read Clark is not so much concerned with the property interests that we're discussing, but more concerned with the use and responsibility in the use of land. There could be exclusive easements. There can be non-exclusive easements. I think the water gets a little muddy there. And so I think really what the point of Clark is that if you are using land, you have a responsibility to others to protect them. And an answer...
But, I mean, Clark does what you just said. It evaluates the relationship between the parties and holds that the district owed no duty to Justin Clark. Is that kind of analysis still viable in light of Gibson versus Casey, which tells us we're not to embark on a factual analysis of the relationship between the parties in determining the legal question of duty? It predates Gibson by several years.
It does predate Gibson, and I do believe that there is both a special relationship in this case between Mr. Smith and Alameda, and I also believe that there's a public policy duty. I believe we, in our response for motions for summary judgment, cited the CFR, wherein you are not allowed to block or restrict a road. I would believe, I would argue that CFR gives rise to a duty if you in fact do block a Forest Service road.
I found that there's a lot of argument over whether that was really a Forest Service road.
Well, and that is a very important issue, and I will answer your question, and I would just begin with this point. I don't know that whether or not it was a road was part of the judge's decision at the trial level, but as far as whether or not this is the road, I think the record, there's certainly a question of fact about whether or not this was a road. Our two contentions being, number one, under the CFRs, if the road is mapped, then therefore it is a road. And then under the permit, in paragraph 17 of the permit, where Alameda was given express notice that roads were open for motor vehicle use, in that paragraph, it states that roads are designated by signage. So there was signage on the ground, as found by the Forest Service in their accident investigation. There was a sign at the intersection stating 9082G, and another sign for the main road on which Mr. Smith traveled. He turned at that intersection and collided with the fence a mere 200 to 250 yards later. So, number one, signage, we believe there's at least a question of fact about whether or not this was a road. And then on the map issue, if you look at Exhibit 8 to our controverting statement of facts, and you look at the map that we're talking about, it's pretty impossible to pinpoint exact locations. Now, I know Alameda has made the argument that the road was someplace else, or there was a northerly route of 9082G, and this goes to our expert opinion that was attached to our controverting statement of facts. In that opinion, he opined that the accident occurred on the southerly route of 9082G. Now, in his report, what he did was he gathered satellite photographs going back to 1959, and in 1959, what he noticed is there were two 9082Gs, and that they were both in use. And about every 10 years, these satellite photographs showed both roads in use. But in the mid-1980s, the northerly route began to appear to not be being used, and as of 1997, the northerly route had completely disappeared. So therefore, the only road on the ground that could have matched the road as 9082G was the southerly route. And that is what our expert witness opined was the road Mr. Smith was traveling when he had the accident. So there's one 9082G on the map, and there's one 9082G on the ground. The 9082G on the ground was the road that Mr. Smith was traveling. So we have evidence pre-accident that both by map and by signage, this was, in fact, a U.S. Forest Service road. So I think this goes back to my argument regarding the public policy duty, and that you're not there's at least a question of fact about whether or not Alameda built this fence over 9082G. I'd like to reserve the rest of my time for rebuttal if there are no more questions.
Hi, Phil.
May it please the court, counsel, thank you for allowing us to be heard today. I'd like to start by briefly addressing one of the points that appellant's counsel made regarding the suggestion that this is a temporary improvement as opposed to a permanent improvement. I was scrambling through the briefing and the motion for summary judgment as that argument was made, and in fact, that argument was not made below. Furthermore, that argument was not made in the briefing to you. In fact, the appellant took exactly the opposite position in their reply brief when they stated on the final page of that reply brief, page 4, by virtue of this regulation and the fact that the fence is undeniably a permanent improvement, it is clear that appellee had an interest through the permit. So they have argued the contrary to position to you in the briefing before coming here today, and they never even argued that position to the court below. So it's the very first time we've heard it. It's certainly not been briefed for you or for the trial court, and we believe that the argument that they made in their reply brief is in fact the argument is framed for you.
Can I completely interrupt you? And
Yes.
If we had to reach the question of whether this was a forest road, that's a question of fact. Let's say I believe that. Hmm? What analytic path do we take where that doesn't matter?
All right. I think it's a question of law because the court is empowered to decide issues of statutory interpretation. The CFRs clearly define that the United States government defines what its designated roads, paths, and trails are.
But didn't it get muddy by the deposition testimony about carcinite signs and things lying on the ground? I just think that's sort of a perilous path for us to undertake as a question of law. Is there an analytic framework that doesn't require us to resolve that issue?
Yeah, and I think
You're getting there?
Yeah, I think that's just it. Keep in mind, it's the federal government, per the statutes, per the CFRs, that designate which of its roads are authorized. Not the state government, not local government, not the general population, the public. The federal government does that. The federal government conducted an authorized investigation of this accident, had their surveyor, Mr. Salcido, out there and confirmed that where the accident occurred was not a designated authorized Forest Service road or trail. It was not 9082G, as appellants argued before you today. So the entity which is tasked with defining which of its roads and trails are authorized says this wasn't authorized. They also provide that any designated or authorized Forest Service road or trail per the CFRs needs to be published in a map. This one was not published in a map. In fact, Mr. Moulin, their expert, confirmed that. Finally, the issue about the Carsonite sign, the only evidence in this case is for a Carsonite sign to establish an authorized Forest Service road or trail, it has to be posted, it has to be up, not laying on the ground.
Is it a trail and a road, or just a road?
It's frankly, in my estimation, but that's my estimation, it's just a path. It's a path.
Well, no, I'm saying, is the requirement the same for roads and trails, or just roads? Because it seems like those terms are used loosely, and certain legal authority would seem to indicate it's roads, but not necessarily trails.
It has to be taken in the context of what is authorized for motor vehicle travel in the United States Forest Service land on the Prescott National Forest, and it requires that it be on a designated authorized road or trail, which says in turn that has to be either in a map or posted with an upright Carsonite sign. That is the undisputed evidence about the Carsonite signs. The Forest Service ranger was deposed, his testimony was provided below, and there was no counter to that from any witness that if a Carsonite sign is laying on the ground, that still establishes an authorized designated road or trail by the Prescott National Forest. And then the other interesting thing with respect to Mr. Moulin, their designated expert, is this. Mr. Moulin reviewed aerial photographs, he took a look at maps, and he confirmed in deposition that he could find no map in history that established that the path that Mr. Smith was on at the time of the accident was in fact designated on a Forest Service or Prescott National Forest map as a designated authorized Forest Service road or trail. He confirmed that in fact he'd seen no record, spoken to no one who ever suggested that the path that Mr. Smith was on at the time of the accident was ever an authorized Forest Service road or trail. In fact, he confirmed that no one prior to him had ever come up with the idea that there was this southern leg of 9082G as opposed to the northern placement of 9082G, which was on the maps and spoken, addressed by Mr. Salcido, the engineer, as the true placement of 9082G. And I submit to this court that I think the United States Supreme Court has clearly defined that if an expert says, I believe it's so simply because I believe it's so, that is not properly considered as evidence and expert opinion in deciding a matter, any matter, including a matter such as this. And that certainly was before the trial court below. So I felt the trial court had the right to consider what Mr. Moulin said, the wholesale lack of any foundation or basis for what he said, and it was within the trial court's discretion to reject that if it deemed so. And
we don't know whether that was the basis for the court's finding of no duty.
I agree, we don't. But the same opportunity is before you since we're looking at this de novo. The reality is that Mr. Moulin is the first person ever in history to come up with the idea that there was this southern leg of 9082G and it was an authorized Forest Service road or trail. He was the only one that's ever labeled it as the southern leg of 9082G. No one in history, no map, and the Forest Service itself has never said that that was ever an authorized Forest Service road or trail.
But do you have to win on that issue to prevail on appeal?
I don't think so, because I think it's a bit of a red herring in this case, because I think that if we take a look at this case as the Clark case, the Gibson court, the Diaz court, the Sabina court looked at the duty issues in their respective cases, I think it's pretty clear that, number one, there is no special relationship that existed between Mr. Smith and Almeida. I think that when appellants make the argument that there was a property interest that existed that Almeida held that somehow creates an obligation to individuals such as the appellant, Mr. Smith, that even if you want to assume that, assume it was some type of an easement as Clark dealt with, even the Clark court says you don't just say there's a property interest and then there's a duty. The quote from the Clark court was, the nature of the duty owed by the owner of an interest in real property must have a relationship to the degree of control confirmed by the scope of the ownership interest. And the interesting thing here is the undisputed evidence is Almeida had anything but control. They were required to build this fence per their permit back in 2003, and the CFRs are clear. Once they built it, ownership vested to the federal government. They had to build it pursuant to fence guidelines and requirements. They couldn't
Would this be a different case if some defect in the fence had caused Mr. Smith's accident as opposed to its existence?
If it wasn't built in conformance,
Or it had been maintained and it caused the injury because of lack of maintenance?
possibly, but then we have to get into a different analysis of the extent to which they had the right and ability to control what was done in that respect. And that's not what we're presented with here. The federal government required them to build it a certain way, required them to build it in a certain location, required them to put gates in a certain location. The interesting thing here also, as much as in the Clark case, you may recall the water district went to the individual that actually constructed the chain gate and said, hey, take this down. He said no. Well, you had a financially capable water district then sue him, and even the court said no. Here, after the fact, but as a demonstration of the ability to control or not, Almeda goes to the Forest Service and says, hey, just so you know, we just had an accident here, which, by the way, the Forest Service was fully aware of since they were sued by the appellant in that respect. Can we put a gate here? The Forest Service said, no, you can't. So that demonstrates the wholesale lack of control. Almeda had to construct it the way the Forest Service told them to construct it.
I can certainly understand after the fact why the federal government might say, no offense, because after all, they're now looking at liability, and so everything is shifted. I'm not even sure that piece of fact would be admissible in evidence, but because of it came after the accident, and now parties are taking positions based on how it's going to help them.
Well, I believe evidence of subsequent remedial measures it can be presented to demonstrate control.
Yeah.
That's one of the exceptions to the rule.
Let me go back on the duty. I want to, in light of some issues that have been created after the Supreme Court's decision in Gibson, duty is a legal question for the court. Okay. Under the restatement, if a party is a possessor, that party has a duty of care, which we simplistically call, or shorthand, premise liability. Okay. Can a person's status as a possessor be an issue of fact?
Can the status, I think given certain facts, certainly anything could be an issue of fact.
Now, in this case, you have argued, as I understood the briefing, that on this record, there really is not an issue of fact as to intent to control. They're just, given the unique nature of grazing leases. Have I perceived the argument correctly?
I think you have. I think that what Gibson speaks to with respect to evaluating the status of a particular individual or entity, it doesn't say that there's a wholesale ignorance of the facts.
There may be a predicate showing to determine whether a duty exists.
Exactly.
Yeah. Now let me explain my quandary here. I recognize fully the significant restrictions, requirements, and directives that the Forest Service imposes on the rancher who holds a grazing lease. But nevertheless, the Forest Service has allowed, authorized, or licensed, permitted the rancher to go onto the property and to use it. And so there's A, occupation pursuant to permission, and B, given all of the requirements imposed on the rancher, it strikes me that there is an inconsistency to say, well, the rancher doesn't have any control over the property because after all, they have to exercise supervision and maintenance pursuant to the regulations and the requirements, but they're still out there in charge of the property.
Well,
and I'm struggling to understand how that cannot be a form of control,
Yeah.
or at least raising a jury issue.
Well, first of all, I disagree that use equals occupation. I can go to the
Okay.
park today and use it. That doesn't mean I occupy it. That doesn't mean I have some right to control what happens there. Doesn't mean I have the ability to create something or limit something. I
Well,
don't
that's
have
so temporary. I won't debate you on exercising a 2-hour slot on a parking meter. Okay, that's maybe on one far end. But let's talk about this case.
Well, in here, the use was defined and permitted by the permit.
You bet.
And the permit, clearly, I believe the federal government has stated in the statute, does not create any type of an ownership interest.
Right.
Ownership interest, which would include a possessory interest.
But clearly, the restatement has discussed that you do not have to have an ownership interest to be a possessor. That's both under restatement second and also the third restatement that addresses this issue, section 49.
Well, I'm not certain we've adopted
Well,
the
either
third
way,
restatement.
you've got to, under the second or the third, ownership is not the required element.
The
It's a
second is
factor.
a person who is in occupation of the land with intent to control it. And I'm hearing you not concede occupation of land and certainly disputing intent to control it. Is that your argument?
Exactly, and the reality is that the federal government defines per the permit what a grazing permit holder can do, what he's required to do. And in fact, if you take a look at the intent of the permit, and I think that's reflected on the first page of the permit, the purpose is for livestock control and protection of air, water, soils and vegetation, fish, wildlife, and other environmental values. That was the purpose of it. It's not for the protection of the motoring public or recreational users. That's the obligation of the federal government, the United States Forest Service. So when it issues that permit, it defines what the permit holder has to do.
Absolutely.
It limits what the permit holder is entitled to do, and then you can look at the permit to understand the intent and purpose, or perhaps public policy behind the purpose, that it has nothing to do with the recreational user. That
I could not agree with you more, but the concern I have that I'm trying to decide is, does this create at least an issue of fact as to whether Almeda is a possessor either under the restatement second, or if, and we haven't adopted the restatement third, I'm not suggesting we go there, but at least under the restatement second. Because they clearly are using the property. They are, in fact, in the colloquial sense, occupying it. After all, their cattle are grazing on it.
I think that you simply need to look to the federal statutes in that respect, and what you're speaking of is even in possession of property interest. And I think the federal statutes speak to the reality that as a permit holder, you have no property interest of any type.
But property interest, what goes into the quiver of ownership for purposes of property is not the dispositive requirement under the restatement test of occupancy with intent to control.
I think that
It's the easy case, but it's not required.
I think if you take a look at Clark and what Clark did in evaluating the extent to which control does or does not exist as it relates to the injury-causing condition.
Let me follow up on that. If your client's permit said no bulls are allowed in these pastures, and your client had a bull, and the bull injured Mr. Smith, does that then fall under Clark?
I think that's a different analysis, and it might. I think that basically Clark would stand for the proposition that if you had a bull, and obviously you have a right to control the bull, it's your bull, and you're told not to have a bull out there, and the bull causes the harm, then that perhaps could be a different analysis. But I think Clark stands for the proposition that you do have to, and you're authorized in evaluating duty, to look at those basic facts, those basic premises, to evaluate the extent to which there is control, to decide whether that creates duty.
And following up on what Judge Norris is saying, I think, at least speaking for me, the struggle is this is such an unusual creature, a grazing permit. I mean, our Supreme Court held in 1940 that it's a mere license, and then later in 1973 said it grants no interest in forest land except to graze a certain number of cattle. It is a very unique, sui generis, whatever that Latin phrase is, beast. And so it's hard to see where it fits along the continuum. I agree it's not Clark. It's different from, less than, less significant, less stable than an easement. But is it a nothing for premises liability purposes? And it boggles my mind that out of the 16 states that have 87% of the grazing in the United States, there's no case law in this. And in part, could that be due to the fact that the United States, as the owner of the land, has premises liability duties?
Well, certainly, I think that's part of it. They retain that. That's their obligation, right? It's their desire. in all candor, that's why there was a separate suit against them filed by Mr. Smith. And those arguments were raised in that suit and alleged in the complaint. The federal government doesn't want to give up those rights. The federal government wants to control what happens on its property. The federal government certainly didn't grant those rights per the permit to Alameda. I mean, that's the reality of this case and the evidence presented below, undisputed, was that Alameda basically has to do everything the federal government requires relative to this fence and this property in order to maintain its permit. Now, certainly we didn't, explore every possible thing you could imagine, but as it related to this accident, this fence, this gate, this permit, that was explored. And the testimony provided both by the Alameda representatives and provided by the forest ranger who was responsible for negotiating and issuing permits was that this is the federal government's property. This is the federal government's fence. These are the federal government's requirements regarding how you put it up, what it looks like, and these are the various considerations that have to be taken into account as to why it's that way. And you can't just do what you want to do as a real occupier or holder of a property interest might be able to do. And so it is down at the bottom of that spectrum of potential, I don't want to say ownership interest, but interest or right to control. I mean, it's a license. If I have a license to drive a car, do I have a right to control the laws that are put up to control what I do?
But there are different kind of licenses. If I license you to run a Renaissance festival on my property in the East Valley for 3 months, I think that carries very different duties from what we're talking about here. So I don't think we can lump it as a license and in the inquiry.
I agree you can in the inquiry. And I think that's why it gets back to, I think the reality of what Clark helps us with, and that is what the Clark court did, and that's they evaluate the extent to which it can control the arguable instrumentality that caused the harm. I think there can be a factual analysis there of what is really the undisputed evidence in this case to ascertain whether a duty exists. I think that's what Clark stood for, and I don't think that, frankly, that aspect of Clark was rejected by Gibson, although Gibson spoke to the idea that, look, we have to constrain ourselves and not start doing all of this factual analysis. There still has to be some analysis that's done in order to understand whether or not, hey, is this a physician-patient relationship? Is this a hotel guest relationship? We have to understand the basic issues surrounding the question of duty in order to understand whether there is or is not a duty. I believe the court's empowered to do that.
Is the essence of your argument then on the control point is because the federal government controlled all aspects of Alameda's use of this grazing land, that Alameda could have no control or no intent to control because it was essentially preempted or pre-opted by the government?
Exactly.
As a matter of law, based on these facts, this record.
Exactly. And
Okay.
Frankly, I don't think you even have to go that expansive in terms of controlling everything Alameda did. I mean, I doubt that they controlled, when Alameda fed their cattle,
of course,
or when they
yeah.
moved them from one pasture to the next, so long as Alameda was not overgrazing.
They
But
had to
certainly,
watch the inches of growth in foliage.
I'm sorry?
They had to watch the inches of growth in
It's true.
foliage.
I know. I have worked with cattle ranchers in this part of Arizona for years and years and years, and what they have to deal with and struggle with is dramatic compared to what we might see in a movie or understand about their day-to-day existence. And that is of no moment here, but the reality is that when you are grazing and creating improvements on federal government property, you are very restricted and very limited in what you can do, and it's defined for you what you can do. But like I said, you don't have to ask the federal government when you can move your cattle from one pasturage to the other, so long as you're abiding by the requirement that you not overgraze. But as it relates to this fence line, there's no dispute in the record that the fence was required to be put there. The fence was required to be constructed pursuant to the federal government guidelines. As appellants conceded in their reply brief, it was a permanent improvement. The federal government defined where the gates went. In other words, defining which were their designated and authorized Forest Service roads or trails, which this was not one of them. Keep in mind, this fence was built in 2003 and accepted by the federal government thereafter as having been constructed in compliance with their requirements. They never required a gate be put there, and then as evidence, even though perhaps subsequent remedial measures, but as evidence of control, the federal government said after the fact, Sorry, I don't care if an accident happened there. You can't put a gate there. So Alameda was constrained, handcuffed in what they could do. Ultimately, we believe the record demonstrates that there was no special relationship, no property interest, let alone ability to control. And if you take a look at the articulated intent of the permit regarding protection of environmental values, livestock control, protection of fish and wildlife, it doesn't deal at all with recreational users, motor vehicle operators in the Prescott National Forest. This is not a class of individuals that Alameda was expected to protect from a public policy perspective.
Thank you.
Thank you.
Mr. Kleifeld got a little bit of extra time, Mr. Winger, so if you need a little bit of extra for rebuttal, you may have it.
I just want to go back to the point that we ended on, and that is, I believe in the permit contains an express notification to the ranchers that Forest Service roads that were signed on the ground and designated were open for motor vehicle use. So I think there is an aspect of the permit where they were given notice of that so that within the scope of what they were entitled to do, that they would act with due care. So I agree that Alameda's ability to use the land and the scope of their use is limited in this case. However, I think it's related to this accident, and that what they were entitled to do was to build, maintain, and use that fence, and that fence was the instrumentality that caused the accident, and the reason why it caused the accident is it was, at a minimum, a question of fact strung across a Forest Service road. Now, I want to get to...
They were required to build that specific fence in that location, and so why isn't it then the owner of the land that directed the injury-causing instrumentality, the United States, who you sued?
Well, I believe that Alameda has conceded both in their motion for summary judgment as well as their briefing here at the appellate level that they were under an obligation to build gates where the fence crossed a road. That has been conceded.
Fine, but I can find nothing in the record, in the permit, in the allotment management plan, in the CFRs. I agree there was some deposition testimony to that effect, but to cobble a duty out of that deposition testimony is a little problematic.
Well, of course, because if you find the duty in testimony, then you're talking about a question of fact and not a question of law. And I think that's the difficulty. The one thing I did want to address that I think hasn't been fully addressed, and that is this strange animal that you, Judge Downey, raised, and that is these permits, and what are they? And the cases cited by appellees in their answering brief, they really focus on whether or not it's a property interest for Fifth Amendment taking analysis. And I would posit that that doesn't, just because it is not a compensable interest under the Fifth Amendment doesn't mean that it's not a property interest. And we did cite in, I believe, our response to the motion for summary judgment that it is considered a property interest under a California case for taxation purposes.
Both of which are probably irrelevant. I agree with you. Both that it's not just compensation under Fifth Amendment, and it is taxation. I agree with you. Those don't answer the premises liability duty question.
And I think the premises liability doesn't arise out of finding some category under property law to place this permit. But again, I think what, again, the proposition in Clark is that once one is licensed or allowed to use, or whatever we say, someone else's land, that they have to do so in a responsible manner. And I think in this case there is an interest that Alameda has. You can't just say this is an at-will property right. I think that's clear from the permit itself as well as the CFRs. That case law does not match this particular situation. When we say it's an at-will permit, there's no compensable taking interest. The permit is for 10 years. If they want to use the land for other purposes, they have to give 2 years' notice to the rancher. If they do take for other public purposes, they have to compensate the ranchers for the improvements on the land. And the permit doesn't specify whether they need to be permanent structural improvements or temporary structural improvements. So it's not necessarily an at-will right that they have. I think there is something there. There are protections to protect their interest in the use of this land. Thank you.
Thank you both for your arguments. It's an interesting case. We will take this matter under advisement and issue a ruling in due course. At this time, we will stand in recess in preparation for our next argument. Thank you.